attacking something a little different with this panel, and then one tomorrow that's media focused. And instead of having our panelists prepare a presentation, we really wanted to allow this to be a discussion that involves you, the audience, and our panel of public lands attorneys. And, you know, given a lot of the things we've already heard this morning and that we all know about the changing landscape that we're facing under Trump 2, it felt like there's just an opportunity to try and clarify some things about, you know, what is the legal landscape in the moment? How do we navigate this world that we live in now from a legal perspective? How can we, as citizens and NGO activists and NGO workers, be effective in utilizing the legal system to advance our goals and our aims, given all the changes that are taking place? And so that's why we're here. That's why we're doing this panel in this way. So please engage. It's just a discussion. We have an hour. So think of questions. When it does come to that time, we'll just try and keep it to questions as much as possible. But we're going to just start by having each of our panelists introduce themselves, tell you a little bit about the legal work that they do and their experience. Then you'll get a sense of what's up on the stage and what areas we might want to focus on in our question and answer session. And go ahead and take it away.
Can you hear me okay? Sounds like this is working. I will start out. I'm Dana Johnson. I am a staff attorney and policy director with Wilderness Watch. We are a national wilderness protection organization. We focus a lot on public education, work with our fellow conservation organizations and individual land protectors just to kind of keep an ear to the ground and find out what's happening, share knowledge about the tools that we have for protecting these areas. We engage the agencies directly and indirectly. We talk a lot with wilderness rangers to find out what's going on with them and what's happening to wilderness programs within the agencies. And we do all the normal things like writing, you know, public comments and engaging the administrative process and litigating. And so my particular expertise is using the Wilderness Act as a tool to protect these landscapes. It's our most protective land management statute, and it was passed to assure that an increasing population with all of our technological advances and growing mechanization didn't modify every inch of land in the United States. And so the statute itself prohibits things like commercial enterprise, roads, motor vehicle use, motorized equipment, aircraft, structures, installations. All of those things are generally prohibited in wilderness. And so much of our work at Wilderness Watch revolves around enforcing those statutory mandates. And more specific to this particular conference, we also work to protect designated wilderness from domestic grazing, which occurs on about 10 to 13 million acres of designated wilderness. And fun fact, since we're in Utah, the High Uintas Wilderness holds the high distinction of having the most grazed acreage within its boundaries of any designated wilderness. So if you live and work here, there's plenty of work that could be done just in that one particular area. And all of this is happening because the Wilderness Act itself has a really short statutory provision that allows for the continuation of grazing, even though it's a commercial enterprise, even though it's often associated with a lot of infrastructure, motorized uses. And in the 80s, a congressional committee came out with what is called the Congressional Grazing Guidelines, and this is basically what provides all of the guidance about grazing in the National Wilderness Preservation System. And so it provides detail on when you can have motorized use, when you can have things like fencing, structures, water tanks, those sorts of things, when you can reduce grazing, when you can increase it. So we focus a lot on enforcing a really narrow interpretation of those guidelines to best protect wilderness. And ultimately, we would love to see those guidelines revised And of course, grazing substantially reduced or eliminated on wilderness altogether. And so some of the big things that we're keeping our eyes on right now are the reauthorization of grazing on vacant allotments. And some of these allotments have been vacant for 10, 20, 30 years. And I know Cindy's looking at some of those right now. We're also keeping an eye on an overall just lack of transparency and an increasing difficulty in just getting basic information from the agencies about the decisions that they're making and the information that they're using to make those decisions. And we're also looking a lot at what's happening with predator killing programs in wilderness, particularly when those are tied to grazing operations. And lastly, and maybe most importantly, given the turbulent times that we're living in right now, we have been focusing a lot lately on storytelling and trying to resituate the work that we do and the value of wilderness and landscape protection in the context of this converging crises that we're facing, so ecological crises, climate crisis, crisis of community and belonging, political unrest, and the exploitation of humans and landscapes, and just kind of trying to investigate the root causes of all of those things and figure out some new stories that can emerge for a better future out of that. And figuring out how we can weave that work through our litigation is also an interesting task that I'm exploring. So I'm excited to talk today about how we as a community can stay nimble in these very difficult times and how we can best protect the areas that we all love. And next.
I did not prepare anything, so this is going to be a mite shorter. My name is Megan. I am the 10th Circuit Attorney for Western Watersheds Project. As I'm sure you all know, we heavily focus on public lands livestock grazing, which can pull in a lot of different laws from FLIPMA to NIFMA to the ESA and NEPA, which I'm sure a lot of you know has undergone some, shall we say, tweaking of late. I will do my best to cover that statute, and with that, I think I'll hand it, is it Matt taking it? Cindy? Okay.
Thank you, Megan. Thanks, everyone. I'm also with Western Watersheds Project. My name is Cindy Toole. I use she, her pronouns, and I'm based in Tucson, Arizona, which is also called Chukchon, and it's the land of the Tohono and Pasquayaqui or Uemi people. As the Arizona, New Mexico Director for Western Watersheds Project, I'm not an attorney officially representing the organization, but I am an attorney. I've been one since 2007. I also have a science degree, and I just have like this really strong desire to protect land. So that's how I ended up in this work, is science, law, and a passion for the land. What I do as the Arizona, Mexico Director is I look at a lot of documents that the Forest Service and Bureau of Land Management put out. They're often forest plans or resource management plans. I will submit a lot of Freedom of Information Act requests in order to get more information about what our government agencies are doing and what our land managers are or are not doing to protect the lands that we all should be working to protect for future generations. So I will be focusing my responses to questions on the Freedom of Information Act. And I'll pass it to Matt.
Thanks, Cindy. Can you hear me? Yeah. I'm Matthew Bishop. I'm a staff attorney with the Western Environmental Law Center, which is a regional law firm in the West. We're actually headquartered in Eugene and teach the Environmental Law Clinic at the University of Oregon School of Law. So thanks for the invite. It's really nice to be back on law school campus. I'm one of the old timers. I started with a full head of hair back in October 1998 in WELC, Western Environmental Law Center's New Mexico office. And early on, I was working a lot on Clean Water Act enforcement cases, Wild and Scenic Rivers Act issues. And then one of my first wildlife cases, I'm primarily a wildlife attorney now, was intervening to defend the reintroduction of the Mexican wolf from the New Mexico cattle growers lawsuit, which was brought by Karen Budd Fallon, who now is at DOI. And it really sort of ignited, I think, in me a passion for wildlife issues. And I remember buying Barry Lopez's book as a young lawyer and getting really excited about the work. And that since has grown into working on other species throughout the West. I'm now back in Montana, my hometown of Helena, Montana. In 2008, I started and opened up the Welks Northern Rockies office. So we're now 4 lawyers there. We're kind of strewn throughout the West. My work primarily is focused on threatened and endangered species, public lands issues. I work primarily on trying to get species listed that deserve to be protected based on the best available science. So a good example of that would be wolverine, where we had 2 rounds of litigation. And thankfully, for political reasons, we had an administration that was receptive to actually applying the best available science and making the right decision. That may change, as we all know. I also work on keeping species protected that should not be delisted. So a good example of that would be grizzly bears. So when efforts were underway to delist, to designate and delist the sort of Yellowstone population, we got involved in that to keep bears listed. I'm also working on issues involving just making sure the Endangered Species Act, all the tools that the statute provides to help conserve, which means to recover species, are being implemented. So some examples of that would be for lynx. I do a lot of lynx work where we had to sue twice to get a recovery plan in place. Or we had to sue to get proposed designated critical habitat, again, driven by scientists, the science designated. And we're also working on Mexican wolves, again, on sort of challenging a 10J rule, which sort of dictates the management of the species, to make sure that's based on the best available science, including the biological needs of the species. And then lastly, some of the work I do is individual projects or activities that may affect endangered species or wildlife species. So it could be a grazing project, predator control, logging, some national monument work as well. But most of my work now is sort of through the threatened endangered species filter or lens. So I'm always sort of looking at an individual project and seeing how that's going to affect one of the focal species I work on. That's about 80% of my work. And then other work is stuff that just comes in that's a little bit different. Like right now I'm working on a case involving the Sonoran Desert tortoise, and we're doing a deep dive on the science to determine whether or not we want to challenge the agency's decision not to list, which I think we do. But what I like about my work, and I feel very fortunate to do it, is we get to work with a lot of scientific experts. I'm working on a gray wolf case. I have a hearing in a couple of weeks in front of Judge Malloy, where we retained Bridget Von Holt, who's one of the leading geneticists on gray wolves in Yellowstone. She's now working with us as an expert in the case. The late David Mattson is a grizzly bear expert who making sure we get the science right. Jeff Copeland is a retired wolverine biologist who I confer with on all the wolverine litigation. I'm still looking for a lynx person, but I really enjoy that aspect of the work. I was actually a history major in college, not a biology major. And I used to think that was a real hindrance to my work, but I now realize in some ways it's helpful because I'm more of a filter between the biologists and the judge and the clerks. So if I don't understand it, they're not going to likely understand it. So it really helps me ask a lot of questions and try to get it right, and frankly, whittle it down to the basics to get it in a legal brief where, as you know, you get about 28 pages in one read to really try to convey the story or the narrative to win the case. So that's enough from me. Josh?
Well, thanks. So we can, I have a few thoughts of things to talk with our panelists about, and then we're happy to also turn it over to questions from the audience. So I think I'll just start out by asking this one question, and you guys can take it as in turn or figure out who should. So let's talk a little bit about today and where we are with Trump 2. We have, the Endangered Species Act. We have changes being made to the definition or the way that harm would be defined under the Endangered Species Act that could have profound impacts on how the law applies. We have changes in the way that NEPA as a statute is going to be implemented and which agency within the federal government and the administration is going to be writing the rules on NEPA. We have, in addition to that, all these new things coming down the pipe that are exemptions from environmental review, like, or short processes to do these environmental reviews. We have a staffing shortage at the agencies. There's a lot, right? Like, and I think a lot of people are feeling a little overwhelmed by all of these things. And so my question is given that the strategy of the administration is to kind of flood the zone, like, what are the things that we really should be focused on if we can't focus on everything? Like, what are the things that are most important for people to understand that are going to create the most profound change in how our legal system works, at least in terms of environmental law?
Thank you for the easy first question, Josh.
You're welcome.
I'll start because you didn't mention FOIA,
I didn't.
and thus far, the Freedom of Information Act has not really taken a hit. Maybe don't publish that information anywhere. But so I don't have much to say on this because mostly what I do is FOIA. So I will pass it off to someone else.
Yeah, thanks, John. It's a really interesting time, as we all know, and there's so much happening, both in terms of the NEPA changes and the regulatory changes. I mean, nearly 50 years of case law was built on CEQ regulations that no longer exist. We're seeing the change to the definition of harm in Endangered Species Act. Internally at WELC, we're having a lot of discussion about it. I think it's important to understand that in some ways these changes cut both ways. So for instance, like the harm definition that previously existed in the regulations had a modifier significantly adversely modifying habitat. If that definition is being removed as being proposed by the Trump administration, then we're resorting back to the statute itself. And our position is Congress clearly intended, based on the plain language and legislative history of the statute, to include habitat modification as a type of take under the statute, along with other different verbs that describe take. So we're going to be resorting back to the plain language of the statute and what Congress meant. And I mean, in the light of Loper Bright and some of the changes from the Supreme Court, we think that could actually play to our advantage. You know, in some ways, the definitional harm, which required habitat modification be significantly modified, might have raised the bar too high. So we'll see how this plays out in court. Same thing with NEPA, by the way. And if you're going to undo the NEPA regulations and resort back to the plain language of the statute, you might be seeing a lot more EISs, frankly. Now, a lot of this depends on what court you're in, what judge you're in front of, and what kind of case you're prosecuting. But it's just, there's just a lot up in the air right now in terms of how all this is going to play out. My sense is, as long as the laws stay on the books, we're going to be in decent shape in terms of being able to hold the line, at least for the next few years. I feel very fortunate to be practicing in Montana, where we have a very solid judiciary that's getting older, but we have some very good judges in District of Montana, and still on the Ninth Circuit. So the judiciary is changing. I think John Leslie mentioned that. For Trump 1 appointed 10 new judges to the Ninth Circuit. It's changing a lot. So I guess my faith as an attorney and as a litigator who primarily is in the trenches litigating cases, my goal and hope for the next few years is to hold the line and really enforce the law. But there's going to be some significant changes that I don't think we're going to go back to the old CEQ regulations on NEPA. I don't think that's going to happen. There's going to be, something's going to emerge from this process that's going to be very different. But my hope, and especially if we can increase the size of the tent and bring in groups, like I represent groups like Backcountry Hunters and Anglers, Helena Hunters and Anglers, groups that really do believe and want to protect public lands and habitat, that those statutes and the purpose will stay on the books and will not be tinkered with. That's my big concern, though, is we lose the statutes, then we're going to be in some trouble.
That was along my thinking too. Yeah, I think most of the concern that I'm hearing from a legal perspective right now is over what's happening to regulations and agency direction. And as Matt said, the statutes are still there. So if those things go away, even if we don't like the changes that are occurring or some of the directives go away entirely, we're reverting back to the language of the statutes. So the Wilderness Act is still there, NEPA is still there, ESA is still there. And because the agencies themselves are getting less discretion in how they interpret those statutes now after Loper Bright, that leaves the attorneys a lot more room to argue about how the courts should be looking at those statutes. And so I think there's a lot of opportunity there that isn't necessarily bad for us. One of the other things that I was thinking about is maybe one of the other bright spots in all of this is we have a good number of judges who are receptive to creative lawyering right now, sort of in the context of the political environment that we're living in and everything that we're facing in our legal system. And so one of the things that I've been thinking about is how we can sort of better think about the way that we advocate for these places kind of from a ground up, and how we in the conservation movement can kind of unsilo ourselves a little bit and start cross-pollinating with people in the climate movement, working more with indigenous communities, and just trying to figure out new ways to get at kind of the same issues that we've been working on for a long time, and to do that through a legal perspective too. We don't often have climate groups, engaging the administrative appeals and joining lawsuits with us. How can we think about these things a little bit differently and start building some more pressure from the ground up? I see that as a real opportunity right now.
I'll be brief, and I might actually pivot a little bit, because I think, show of hands, how many are actually attorneys in here? Okay, that's kind of what I expected. So I think the way that most people are going to be engaging is through the comment process. And in the comment process, I think it is actually kind of a mistake to make your comments look like a legal brief. I think that trying to put all that legalese in there can kind of detract from what you're trying to say. So the lawyers come in, and we're the ones that need to do the legalese and make the creative arguments. But for folks that are engaging in that comment process through NEPA, you're the ones that know the area, you're the ones that know the facts, and you're the ones that have the opportunity to bring points up that might have been missed by those land management agencies. So I really encourage you to kind of untether yourself from what you've learned about NEPA and what you need to put in those comments, and take this as a space to be creative and advocate for what it is that you want protected there, and then leave the nuance of that to the attorney that's going to come in later, assuming you have an attorney. And then the other thing that I would add is that what you put in there is really going to depend on your relationship with the land management agency. Sometimes people that are in those positions are very approachable. You developed a relationship with them, and they are open to hearing what it is that you want to see changed there. Sometimes they're not. And that might kind of change the tone of what you're doing there. But remember, in this instance, you are the specialist. So don't feel like you need to advocate the way that we would necessarily advocate. I would encourage you to advocate in your way, which is also maybe going to bring some kind of bounce to your work in this time when it is really hard to find the energy to rise to the occasion.
Yeah, you go.
Building on what Megan and Dana and Matt said, I feel like I do a lot of comment writing, and that I also spend a lot of time on the land, checking out grazing allotments, checking out places I want to protect. And I think I want to change the way I do my comment writing to reflect not only my relationship with the land manager, but my relationship with the land. And to Dana's point of storytelling, I think we have moved away from that, and we got into very technical, legal, and scientific comments. And I've seen people do this over the last 10 or 15 years that I've been doing this work, but very rarely. Like, we can also be creative. We can submit works of art to the comment process. We can submit poems. We can submit drawings. We can create maps of the places we love that have words on the maps that tell the land manager why we love that place. That also is going to disrupt the AI algorithms that they're using to analyze our comments and ignore our feelings. That's how I would change it.
Yeah, and just to add to that, you know, when I was a young lawyer just starting out, I remember I was working on a case for forest guardians back in Santa Fe, which is now wildlife guardians. And I was talking to John Horning, and there was an issue, I can't remember what it was exactly, but I remember saying that there was bad press. I remember saying something like, well, I don't really care what the press says about it because, you know, the law says X and they violate the law, so we win, you know. And thinking about it, it was just so naive because, I mean, we really are. I think the best lawyers are the ones who really know the facts inside out, because anyone can cite a case on cumulative effects that's going to support them or not, you know. It's all about the facts and it's about the stories. I think the best lawyers are storytellers because you have to get the court to care, right? I mean, if you think about these busy district court judges with a docket of about 300 cases, half criminal, half civil, very complicated administrative records that are massive. They're getting smaller, but still, these are complicated cases. Like, I was just briefing a case on road grizzly bear standards and secure habitat standards for grizzly bears and whether or not 10 acres was sufficient size for foraging bear. I mean, you really kind of get in the weeds, and if you can't simplify it and tell a good story, I just don't think you're going to get the judge or the clerks to care. And this kind of goes back to what Megan said, which I think is great advice in terms of the comments. The people who know and use and love the landscape the most are the ones who are going to really tell the best stories. And so it's critical to get that information in the record in front of the agencies. And the lawyers can come in later, or maybe in addition to, and make sure certain issues are raised or citations provided. But at the end of the day, it's about the stories. And I've had a federal judge tell me on some of these complicated cases where you have, let's take a logging case with lots of different units, he really loves seeing maps and illustrations, because if you're talking about areas and places, nothing's better than a colored map to sort of say it all at once. So I just want to emphasize the importance of storytelling in our work as lawyers.
Thank you. Let's go ahead and see what questions you guys have.
Great. I'm curious what all of you think about the Trump administration's issuing these states of emergency. I mean, I am not an attorney, but it strikes me with what 28-day EISs and what is it, 2-week EAs, and it strikes me that this administration is just going to issue permits left and right and make you fight over them. And I'm wondering if one of the strategies is going to be to just go right at it and challenge, well, there is no timber emergency or oil and gas emergency, and how difficult that will be to fight if they're just issuing the permits and like, well, screw you, we're gonna drill some holes and cut some timber, and we got a permit in hand.
That's a great question, Nick. And we're having a lot of discussion internally at WELC. We're only about 25 lawyers or so figuring out how to go at that. There was a case brought, was it a few weeks ago, by this 11 states challenging the fake emergency order. I can't remember what it was related to exactly, but the consensus at my organization was that states are well positioned to kind of bring those cases early on in light of like the massive EPA decision, because what's hard for us is if you want to bring a challenge to a specific executive order or a declaration of an emergency, if you want to go to court on that, you have to prove standing. So it's always hard to sort of tie that to a specific, injury cause redressability for an individual plaintiff. And I think I'm just kind of talking off the cuff here, but I think that presents a challenge. Like, it's always much more favorable to have a specific concrete example of how that EO, emergency order, allowed this project to go forward and therefore is affecting my clients in certain ways. It's sort of the ticket to the key to the courthouse. States can do that a little bit earlier because of state interests, but it would be nice to actually not have to do that individually, and I don't think we're going to have the capacity to do it. I know in the oil and gas context, we're looking at bundling decisions and lease sales all at once, so you could do a bundle approach. But you're right, there's going to be a flood of litigation over individual sales, all tied to these shortcut procedures with respect to NEPA, and not to mention, as someone mentioned earlier this morning, staff shortages at the agencies, which is going to make their job even harder. Like, I don't know how they're going to be able to write sufficient EAs, let alone EISs, in the time frame provided. It's just not realistic, and with a short staff, which is going to create more litigation and more problems. So we'll have to see how that plays out.
I would just add that one of the problems that we will see more of related to that is just lack of notice of what's going on. A lot of these decisions just come out really quickly without any public notice or opportunity to be engaged at an administrative level. And so I think to the extent that organizations or individuals have ears within the agencies where you can get some notice, from friendly agency staffers or anybody else who might be in the know, now is a really good time to sort of foster those contacts and develop those relationships if you have them.
Yeah, thanks for the comments. So I'm encouraged to hear, working with Indigenous communities. And so I think there's an inroad there as well. What's preventing us from bridging that gap? Let's say the Nez Perce tribe wants to exercise their treaty provisions in the Clearwater, Nez Perce Clearwater Forest, non-consumptive use of wolves or grizzly bears, or maybe even consumptive use. That's a treaty violation if, one, the habitat is being reduced, two, Fish and Wildlife Agency in the state of Idaho's exterminating all the wolves, and I work with bison, so you got wild bison in the park. If the bison cannot access their habitat outside the park, that's a violation of my Fort Laramie treaty rights, because I might want to go out and have non-consumptive use in my traditional and custom harvesting areas for non-consumptive use or even consumptive use of my Aboriginal food source inside the park, in the Gallatin Forest, in the Madison Forest. I'm trying to get tribes to intervene in the Montana versus the National Park Service on the Bison Management Plan right now based on a treaty rights violation and treaty purposes. How can we bridge that gap?
Yeah, good question. I think we just need more communication and trying to figure out how we can work together on a lot of these issues. I know I'm in Idaho, so a lot of my litigation experience and just sort of organizing experience is in Idaho. And so we've actually done a fair amount of work with the Nez Perce tribe, on wolf-related litigation and things like that. One of the other things that we're working on a lot right now is with sort of recreation overuse of a lot of these areas and the impacts to wilderness and also to treaty rights due to that overuse. And so that might be another example of, where there's some good overlap and we can have some concerted effort and working together on things. And just going back to the storytelling part, in all the conferences that I've been to and all the people that I've talked to, the stories that really just sort of hit me in the gut tend to come from Indigenous people and Indigenous communities and their ties to the land. And so I think we just, speaking broadly, need to get those stories elevated and figure out a way to sort of not think about litigation in a silo too, but sort of think of this more holistically. How do we raise these stories to a higher level in even just the agency decision-making process? And this is something that Cindy was talking about too, We should stop letting people define the boxes that we are working within because it is so constrained and we are not winning. And so we need to expand what that box looks like, and we need to figure out how litigation, can sort of facilitate that expansion as well.
I hear the question is like, how can we get Indigenous communities and Indigenous governments to work and environmental organizations to work together more effectively and to find where we have issues that overlap. And I think we haven't done that well. And I think part of it is fear on the part of, I'll speak for myself. So I often have fear that I'm going to overstep, that I'm looking at the environmental movement's history, which is very problematic in how it treated Indigenous communities. There's a lot of racism. There's a lot of paternalism. So I don't want to continue that. And I don't have a good sense of how to change that dynamic. So, for example, I really want to get the Sonoran Desert tortoise listed as an endangered species because it's on its way to extinction. It's a really important cultural part of the Tohono O'odham religion and the O'odham religion more generally, but specifically for the Tohono O'odham. I knew that my work to try to protect the tortoise could have some pretty significant impacts on the sovereignty of the Tohono O'odham nation. And I didn't want to just barrel into that unthoughtfully because I have this desire to protect the tortoise. I also have an obligation to my community, which I live on Tohono O'odham land. The Tohono O'odham are my community as well. I'm not O'odham, but they are part of my community. And so I think I was too timid in reaching out and saying, how can we work together? And then there's also the complication that a lot of white environmentalists, we don't understand Indigenous and tribal law. It is really complicated, as was mentioned earlier. And we're often so stretched thin, we're not making the time to try to understand it, and I think we have to do better. So I'm trying to build relationships on a very personal and legitimate and genuine way with both tribal community members and the tribal government. And that takes time, and I feel like we don't have time. We're running out of time. So, but you don't want to rush it because you don't want to make things worse. So I feel like the fear is kind of keeping us from working together more effectively.
I think Cindy said it best. I don't have a lot to add, except to say that just from my perspective, I think the tribal interests need to be front and center in their own case. I think it's very difficult to have a coalition of organizations, including tribal interests, and try to brief 3 or 4 issues all in one case and have that issue plus other issues. I think it's better on its own with a tribal lawsuit representing and focusing on tribal interests and telling that tribal story. We really tried to do that, and they did do that in the grizzly bear litigation on Yellowstone. I represented Wildlife Guardians. There were some other groups represented, but there's a lawyer out of Colorado who represented the Crow tribe and a host of tribal interests. We really stepped back, let them be the lead, and took direction from them. I think that worked really well. I think that's something that should be replicated, as opposed to having 1 or 2 tribal clients with traditional environmental groups and trying to tuck it all in one 30-page brief and trying to tell those stories. It doesn't work. So I would encourage, on the bison issue, I think you want to have your own voice, intervene as your own party, representing your own interests. That'd be my one recommendation from practical experience.
I'll just add really briefly, tagging on to what Matt said. I've actually had the opposite experience in that we did have 2 tribal members as standing declarants in one of the cases that I had, and their declarations just ripped my heart out and went totally unrecognized by the court, which was very, very hard. So I agree that I think folding tribal members in does a disservice to their unique perspective and voice. And I think just practically, as a sort of new attorney myself, what I really have been craving in that aspect is somebody who knows tribal law, because that's just not me. So that's been kind of something that I have on the back burner is, where can I find the attorneys that specialize in this and make those connections so that we can actually foster that dialogue and get those suits going?
This is a great conversation so far. Thank you very much. Given that we're in an era in which the executive branch has shown willingness to disregard Supreme Court rulings, how do we adjust our strategies to account for that possibility if it ever pops up its ugly head in the conservation realm?
Okay, well, I'm just gonna jump in and say I don't think you do. I think trying to adjust your strategy on what may or may not happen at the Supreme Court is too tenuous a web to be walking right now, and I think that's the simplest answer.
I don't have too much to add to that except to say that, I mean, as people talked about, that's a constitutional crisis if you have an unambiguous court order that is being ignored. I mean, maybe we're there already. I know there's a lot of discussion about that. I'm not so sure. But I know internally at my organization, I don't think we're going to see a lot of settlement agreements anymore. But things that we used to do and agree to that maybe would be sort of a side deal with the agencies, we'll no longer do that. So we're going to ensure that anything we do is contained specifically in the agreement and enforceable by the court. But I've already gotten some pushback from DOJ on specific language that apparently they no longer want to include in a potential settlement agreement. So this will be interesting how that plays out. Again, I feel very confident in sort of the District of Montana where I litigate that we have just solid judges who are really willing to sort of apply the rule of law. And we're willing to fight it out more than maybe normally we would have, 4 years ago, we would have settled something pretty straightforward. Now we'll just litigate it out because frankly, the DOJ and the Environment Division of the DOJ is seeing a lot of changes too. And they're short-staffed and frankly, a lot of their good lawyers who are opposing counsel, who I really appreciate litigating against, are leaving as well. So it's going to be really interesting to see how this plays out, right? We're only 100 plus days in, so it's all very new. But I'm really curious to see how this plays out. I have a couple cases now where we have draft settlement agreements or kicking around language, and I've already heard internally that these are not going to fly within DOJ. They have to be approved up through the AG's office. So it's just going to be more litigation, more fighting it out, more battling it out, which really reinforces the need for a solid, really good judiciary. And that's what frankly makes me a little concerned with judicial appointments coming up, because they're lifetime appointments, right? So I don't know what the vacancy numbers are like. We have a lot of older judges in Montana who are ones on senior status. So I hope we can hold out for another 4 years, and then we'll go from there.
So I feel like we just had an experience where the Supreme Court ignored a lot of their precedent yesterday, Tuesday. They denied Apache Stronghold's, I think it was their appeal to the Supreme Court, to try to get their Religious Freedom Act case heard. And they just decided not to take it. So the court's inaction actually ended the legal fight for Oak Flat. And some of the dissent, I haven't read it carefully yet because it was just yesterday, but some of the dissent in the decision not to take that case said that had this been a white Christian church that was going to be destroyed by a mining company, they absolutely would have heard this Religious Freedom Act case. That the right to practice your religious freedom, which is fully dependent on a specific place on the land, should not be taken away by a midnight decision by Congress to give that land to a mining company. The Supreme Court decided not to take that case. The legal fight appears to be over, so what do we have left to do? We don't have the laws to help anymore. People have been staying at Oak Flat for, I think, over 10 years. They've been consistently camping there, holding ceremony there, and long before that. But once Oak Flat was given to the mining company, essentially, through the Forest Service, people have been fighting really hard to keep it safe. And part of what they've been doing is just staying there. And I think that's the only tool we have left. Once the laws are taken from us, then we have to place our physical selves in the way of the destruction that's going to happen.
Hi, I appreciate this, going back to maybe the initial question. I appreciate saying that in comments you don't try to do a legal brief, but I want to push back on the idea that the attorneys will figure out everything. My earliest experience with NEPA was a non-lawyer citizen in Oregon that recognized the potential to use the worst case analysis provision, which doesn't exist anymore in that form in NEPA, to fight the aerial herbicide spraying over the forests. And that eventually was the key to ending that aerial spraying. Secondly, more recently, a couple last years, a citizen used the word significant in a questioning of a CE, and just that word never went to litigation. That word made the forest supervisor start over on the process, realizing because they'd used that word significant and backed it up, it was going to have to go to an EA. And then thirdly, knowing that in NEPA Act is still required alternatives, knowing that we put in alternatives, complete alternatives at the comment period, which triggers, in some cases, the inclusion of that alternative, and that has made then a difference in the EIS. So I just want to push back on the idea that citizens shouldn't pay attention to knowing some strategies in the laws themselves. Maybe you want to comment on that.
I think we're actually saying the same thing. Whoever does the comments acts as the expert, and I generally rely on the comments or the objection or, however much documentation I have from the person who diligently went through the NEPA documents to inform my understanding. And where I come in is combing through the case law and finding the good quotes to put into the brief, but the comments themselves really hone what I am looking at. So I think that was more what I was driving at, was that you don't need to know what came out yesterday in the District of Montana. I do, but you know this project and you know this area, and you're going to tell me where to look. To a certain extent, but I think if you've engaged in a comment process before, you probably know enough. I think you understand how the statute works. Like I said, you don't need to keep acquainted with what has happened most recently, probably unless it's a Supreme Court decision, in which case you should know that. But those smaller pieces, I think, kind of clutter up a comment and make it difficult to get to the story.
I think it's important for activists to understand enough about the law to know which issues to bring. And especially when we're working with attorneys, it can be easier. Because if we're working with attorneys early on, we can share our issues that we're going to bring up, with our attorney, and they can say, hey, you've missed a big one. Like the Clean Water Act also applies to a lot of grazing cases. Make sure to say something about water quality, say something about E. coli. Do I need to cite a statute for the Clean Water Act? No. I do need to raise the issue. I don't have to know it intimately as an activist. It helps just to be able to spot those issues and make sure people are raising them in as many different ways as possible. But yeah, I think activists need to know some law. We don't have to be experts in the law.
Yeah, and I think you're talking about some technical expertise too. I love the idea of creating your own alternative. And there's a lot of people, particularly in the grazing context, that have a lot of really excellent data and just technical expertise that you're not going to find in the agency documents, and they're not going to promote an alternative that would be much better for the landscape. And so I think in addition to having sort of a baseline knowledge of the legal landscape, getting a very thoroughly presented alternative in there is an excellent strategy too.
And I was just going to say, it's critical to actually attach and provide the documents. So lots of times people would just provide hyperlinks or reference a study. I had a case recently involving a grazing decision just north of Yellowstone where the client coalition raised a bunch of great comments, but there was some missing information from a Dave Mattson 1993 paper. It's like a really critical graph on a spike in grizzly bear mortality in the region that was really tied to the decline in whitebark pine seeds. And so bears were actually eating more meat and getting in more trouble with livestock and hunters, et cetera. And it was a really critical graph that I wanted to put in the brief, but we didn't have it in the record. And I had an affidavit from Dave to try to get in the record, but it's very difficult to do that as well. But I came across these comments from the Buffalo Field campaign. I don't know who wrote them, but they were very extensive. They had about 20 papers, and there it was, on the bait stamp 10,000 whatever was Dave Mattson's 1993 paper with the graph I needed in there. So it's just a good reminder for people, citizens, if you're participating, if you know the area, submit photos, submit relevant studies. Don't just reference them and state them. You actually have to provide them now, and that's just critical piece.
Finally, a FOIA issue. So a lot of times we submit a FOIA request for a project record, and we'll be submitting an objection or an appeal, or maybe even writing comments. And we'll see something in that project record that is really good for our side. And so we just reference it because we're like, well, it's in the project record, the government has it. It may not be in the administrative record. There's a difference. And so anytime I find something through a FOIA request, however I made that FOIA request, that is helpful for me in my comments that I think I might want to use in court, I cut and paste or I screenshot that thing and I put it in my comments and I attach the document. If it's a huge document, I attach the specific pages I need and maybe the whole document, but I make sure the part I care about most is in the record. If you don't do that, it's a battle, and we don't need to have those battles.
No. We are running a little bit behind schedule. So unfortunately, as wonderful as this conversation has been, and I know that there's lots more questions and discussion to have here, we're going to have to end this one here so we can get started on our next panel without too much delay. If you need to get up and just take a bio break, please do that. But otherwise, we're just going to bring our next panelists right up and get started. Thank you guys so much for joining us today. Super informative and helpful.